Welcome to the Probate Nation. My name is Richard Ruddy. Like a slow-moving steam engine train, probate has a beginning, several stops along the way, and at the end of the trip, the balance of the probate assets remaining are delivered to beneficiaries. Some probate train rides are short, other probates seem to never end. In the show tonight, we're going to learn the nuts and bolts involved in probating an estate in South Carolina, beginning when you are legally qualified to act, to when you wrap up and distribute all the assets to the beneficiaries. And we will cover important duties and deadlines to keep in mind in the course of your probate journey. With us tonight is a South Carolina attorney who will share her expertise and guidance on this topic. So let's meet our guest and get started. We are pleased to have with us the founding attorney of the Charleston Estate Planning Law Firm, a boutique law firm in Charleston, South Carolina, that focuses solely on estate planning and probate administration. She enjoys helping individuals and families plan for disability, illness, and death with proper estate planning. And she also assists individuals with the administration of estates through the South Carolina probate courts. Please welcome Eleanor Washburn from the charming city of Charleston, South Carolina. Welcome. Nice to have you join us.
Thank you. Thank you so much for having me.
Our pleasure. So let's get ourselves started here with a little bit of an introduction. Tell us a little bit about what court oversees South Carolina probates.
The South Carolina Probate Court oversees probate. We have a probate court in every county of South Carolina, and so every probate court has it's a county court, and it has a probate court judge, and usually a staff of clerks, depending on how large their, the county is population-wise.
And how does the probate court get involved at the outset of a probate?
The probate process begins with the filing of a petition with the probate court by a person who is requesting to be appointed as the personal representative of the estate in order to administer the estate. So that's generally how the probate court initially becomes involved.
You know, Eleanor, we discussed in preparing for this show that many of the filings with the South Carolina Probate Court are done on court-approved forms. Could you share your thoughts on the advantages and disadvantages of these forms?
So the forms, the South Carolina Probate Court has forms that make it a little bit easier for a lay person to administer an estate or to do what's required. So there's certain forms for certain processes in the court. And so that's a good thing because sometimes if there's a small estate, there's not so much to do. Somebody can do it by themselves. Generally, though, an attorney should be hired, but it makes it also easier for the attorneys and their staff to help somebody with a probate estate. Doesn't take as much time.
Sure.
Doesn't cost as much money.
Of course.
So that's the advantage of it.
And of course, I guess I have to ask the kind of the threshold question, are all probates the same in South Carolina?
No, there are different types of probates in South Carolina, depending on generally a lot of different things, but there's a small estate probate, there is informal probate, formal probate, there's a subsequent administration kind of probate case, and also there's of course, we also have ancillary probate. So those are generally the different types of probate.
Of course, I guess one of the things that always comes into play is we need to know whether or not, maybe it dictates which way we go, is whether there's a will or not. Okay, so
Exactly.
So people die with a will, and some die without a will. So could you begin with an explanation of the consequences of dying without a will versus dying with a will?
If you die with a will, we call that dying testate.
Okay.
So if you die without a will, we call that intestate. So it would be an intestate probate. And when you die with a will, the will lets everybody know what you want to happen with your assets, who you want to have them. When you die without a will, you don't have any control over that, and that's governed by the laws of intestate succession. And so that's the other thing is the will can give your personal representative certain powers that if you don't have a will, the personal representative would have to there's a lot more court involvement because the personal representative would have to get these powers by a court order, essentially.
Now, if any special concern, I know you mentioned this, but I want to bring it out to our audience. Any special concerns you see with the South Carolina intestate statutory will?
Well, one of the problems that I see most of all, and I find it the most unfortunate, lots of times the state is getting it right. You know, if you are not married, have no children, and your parents are still living, your estate will go to your parents. If your parents are no longer living and you are married and have no children, everything goes to your spouse. You know, those types of scenarios. But in one case, it's a little bit, it can be really unfortunate, and that is when you are married and you have children. In that case, and you die without a will, 50% of your assets will go to your children and 50% will go to your spouse. So a lot of people don't understand that, and that can have pretty unfortunate consequences when your children all of a sudden are own your house or part of your house, and maybe they might even be minors. So it becomes very difficult for you to sell your house, finance your house, you know, a lot of, you know, things like that. Sometimes when they're adults, it's not so difficult, but it's very difficult when they're minors.
I can see how that would be the case. Well, I'd say so I guess we really want to find a will if it exists. So if the will is in a safety deposit box, how can that be obtained?
There are provisions in the South Carolina laws in order to be able to access that. It's a somewhat state specific. There's two different ways to do it, and I have seen the judges require one or the other. One of them is when somebody could file a form that just requests that they be appointed as a special administrator, because, you know, we can't appoint the personal representative without the will because we don't know who that's going to be. But they're requesting to be appointed as the personal administrator, just for the purpose of accessing that safe deposit box.
Sure.
And getting the will out of it.
Okay.
In that situation, they certify that they believe the will is in there, or they've been informed the will is in there. But once they go to the safety deposit box, find the will, then the appropriate person will file the normal paperwork to be appointed as the personal representative. The other way it can be done is just by affidavit, where somebody can, ask the court for an order allowing them to access the safe deposit box, and the judge will sign that form, which is an order that allows them to access the box, but the only thing they can remove from the box is a will, if there's one in there, any estate planning documents, cemetery plot deeds, life insurance policies, and then they can inventory the rest, and within 30 days, they have to report back to the court with what they found in the box. And so that's two different ways to do it. It just depends on the judge that you have,
okay,
and the county that you're actually filing in.
Okay. Well, let's go on and talk about the whether there is a will or not. Give us an overview of the probate process. You know, how do we get the process moving, whether there's a will or not?
The probate process starts in South Carolina with a petition. It can be either an informal petition or a formal petition. The only difference with those is with a formal petition, it's usually when we have some kind of issue in dispute, and we're requesting a court hearing. But if it's informal, it starts with a petition. The judge, a petition signed by the person who wants to be appointed as the personal representative. It tells the court a little bit about the case so that the court can establish they have jurisdiction, like that the decedent lived in that county, those kind of things. who the heirs are, who the people are named in the will if they have a will. So it's like a complaint essentially. And once that is filed and the court is satisfied, they will sign an order appointing the personal representative. At that point, the personal representative can then begin to gather information and find out what it is that the decedent has left in terms of property. Then in the note, all of the heirs and devisees or heirs and people named in the will are notified once the personal representative is appointed. Then there's an inventory and appraisement that the personal representative has to file within 90 days. And then there's a creditor period, and the personal representative has to wait and see if any creditors' claims are filed and deal with those, pay any expenses that are valid for administration of the estate, maintaining property and that sort of thing. And then once that creditor period is expired and all the creditor claims are dealt with, the personal representative would distribute, the property.
Okay.
Once they've done everything, then that's it. They get discharged.
Now, how do I know? I file my application. How do I know that I've been appointed?
The court will send you a certificate of appointment.
Okay. So,
and yeah, it's a legal document that they usually send you a few of them, kind of like a death certificate, because you might need them for different things.
Okay. Well, tell us a little bit about this. Sort of switch gears now. Tell us a little bit about the difference between being an heir and being a beneficiary, because there is a distinction there.
Right, there is. And so, like I said, in our petitions, we have to identify all of the people who are named in the will. And we also have to identify all the people that would have inherited from that person if they had not had a will. And those are your heirs. So you don't necessarily, you might have heirs, but they're not included in your will. Those would be, they're both beneficiaries, but those would be beneficiaries that may or may not be your heirs. In our forms in South Carolina, the court will call them devisees. So in other words, they've been devised something in the will. So they're they're the ones who get all the paperwork from the court, and the heirs just get notification that there's been a will probated and somebody's been appointed.
Sure.
And this is, of course, in the case where there's a will.
Sure. The importance there, of course, is that if there is a will, we want to let everybody know that that will was admitted, so that if there is not a will, that the heirs get notice in case they want to challenge the will for some reason.
Yeah, that's the theory behind the notice requirement to all of the heirs, yes.
Tell me a little bit about the duty. Let's switch gears now and go on and talk about the duties of the personal representative in South Carolina. Regardless of how the estate's probate, what are some of the most important duties that a PR has?
Well, I went through some of what the process is, so that also, but in more detail, what the personal representative has to do is, the most important thing is to determine what is the property that the decedent owned when they passed away. Try to figure out where everything is. And sometimes that can be difficult. And then make sure that all the expenses are paid. Like if there's real estate, the utilities have to continue to be paid. Basically, protecting the asset from any waste or damage. They have to open an estate bank account, and any other accounts that need to be closed, everything will be poured into that estate bank account. They have to determine the validity of creditor claims, which is very important. Sometimes they can negotiate those claims if there is not enough money in the estate, or if there's some question about whether or not it was really a valid claim. And then they have to sell the property of the estate if that's appropriate, and then distribute all of the assets, appropriately.
Now, the personal representative has to file, no matter what way we go, we still have to file an inventory. Is that correct?
Yes.
Okay.
Yes.
So I know that we talked about that. So at least everybody knows what assets we know about. In some cases, you may have to file an accounting. In some cases, you don't have to file an accounting, as I understand. Is that correct?
Right.
So that's good to know. So that, but when they file an accounting, if they have to file an accounting, do they have to provide supporting documents to support everything, or can that just be deferred until somebody challenges the document?
Right. So we have a form that has to be filed by the personal representative that's an accounting, and it's basically a very simple form. All the money that came into the estate, all the money that went out of the estate during administration, like, creditor claims that were paid, attorney's fees that were paid, probate court fees that were paid, utilities that were paid, all of those things. And then essentially what's left and how that's going to be distributed. So of course that information comes from bank statements, and you have that in receipts and things. You have supporting documentation, but initially the personal representative just has to file the form itself, a 2-page form that they have certified, and that accounting is sent to all of the heirs or beneficiaries. And if they have any issues with it, if they don't believe that it's accurate, they can request a hearing. They can request that the court determine that. And so at that point in time, the personal representative would need to get all their supporting documentation to back up, their numbers, so to speak. And that accounting also can be waived if if the beneficiaries want to.
Okay.
It saves money when they waive it, because it's, all that time is not being spent on, creating the document.
Okay. All right. You mentioned a little bit about creditors, so let's talk about that. Is there a publication requirement when someone dies to somehow put everybody on notice that person died, and if you have any bills that need to be paid, that you should submit them?
Right. So when I forgot that part, but when the personal representative files the petition and is appointed, they have to publish a notice in the paper to creditors, and that notice says that the creditor has 8 months to file a creditor claim with the probate court in that county. That's run for 3 consecutive weeks. We calculate that 8 months from the first day that it was published. So a known creditor or an unknown creditor has 8 months. And unknown creditor has a year. So no, a known creditor has a year. Yeah.
Okay. And the notice has to be published in a paper of general jurisdiction, where circulation, right, wherever the people are. So
general circulation in the county,
where the person that passed away.
Yeah, any paper usually that's published and available in the county.
So the key with the notice, I think we talked about this when we were preparing for the show, is that if someone didn't probate their estate until a year after someone died, then potentially creditors could be cut off completely. Is that true?
Right, that is true. So if a probate or will isn't probated or estate is not opened within a year of the person's death, there will be no need to advertise for creditors. I guess the theory behind that is a creditor can open probate as well. So that's sort of the theory, I think, in South Carolina for that. If they could open probate themselves, and so that's the theory behind that.
Sure.
And if they haven't done it in a year and nobody else has done it, the statute just bars their claim.
Okay, and that's important for people who get qualified. That's important for them to know. Now, we've gone through all this process. We've gathered our assets. We filed our inventory. We maybe have gotten the accounting waived. We did our notices for creditors, paid people, so on and so forth. So it looks like we're at this point pretty far along in the process. How do I wrap it all up?
So we wrap it all up once the creditor period is expired. And again, that accounting, which may or may not need to be done formally, we need to figure out what we have left to do. And we have to distribute the cash assets. If there is real estate that we're going to be doing a deed for, we can go ahead and do that. If we haven't sold it while it was in probate. Once we've distributed all of the assets, we get receipts from the beneficiaries, and then we file those receipts. We have to notify the beneficiaries. Like I said, the beneficiaries can waive all of these final documents, but generally the personal representative would send an accounting, a proposal for distribution, which lets the beneficiaries know how much everybody's going to get. They have a right to a hearing, and so they have a note. It's a notice that they have a right to request a hearing if they don't like what's been done. Then after that after 30 days have passed, then the personal representative can issue the checks or convey the property and close out the estate.
And that process then, the judge eventually signs off on that, so you have that paper document that you've been approved, and you can go ahead and close everything. You officially closed out. Well, we're getting near the time where I want to get some closing comments and suggestions, ideas, pitfalls. This is advice you want to give folks who might decide to probate the estate themselves in South Carolina. Things they might want to watch out for. Especially given your experience, I think it'd be very valuable to hear what you have to say.
So I think that some of the problems that I see sometimes is that they don't do the things that the court's requiring them to do, and they don't do them on time. So that's why it's also really important to pick the right person to be your personal representative, the person that's going to get the job done. A lot of, sometimes when people have not had an attorney and they end up coming to me, of course, that's when I see them, they come to me. It has just become overwhelming for them, and they have missed all of the deadlines, and the courts are sending them letters, and it can be overwhelming where an attorney can sort of guide you through the process. So a step at a time. The other, I guess that's the biggest thing is just not getting it done. I mean, it's a job, and we have to take it seriously and get it done.
What's the normal time frame it takes to probate an estate in South Carolina typically?
It is about a year. Like I said, the court is very anxious for you to do the things that you're supposed to do. And so they monitor all of these cases and their timelines. And if you're not haven't shown the court that you've done certain things, they can actually rule you into court and ask you why you haven't.
Okay.
It is a very streamlined process that's really designed to be done in a year. Now, there are times that, that's not possible because we have other issues, outstanding issues between beneficiaries or with property or other kind of things that can come up. But just in a normal case, we can get it done in a year, and the court's going to want to know why you haven't finished everything in a year.
Okay.
So that's good. It's pretty reasonable, I think.
12 months is a good time frame. Yes, yeah. Very much so. Well, look, we're at the point in time where I have to say thank you on behalf of the Probate Nation for taking the time to visit us and for sharing with us an overview of the South Carolina probate law, as well as, frankly, your advice as to what to do and not to do in the course of a South Carolina probate train ride. Valuable information and a great public service for those viewers confronted with the South Carolina state to be probated. So thank you, Eleanor, for taking the time.
Well, thank you for having me.
Without a doubt, probate can be complicated and confusing. Tonight, our guest has given us an excellent introduction to the South Carolina probate process. If you need to initiate a South Carolina probate, be sure to check out all the useful guides, forms, and checklists available online from the probate courts in South Carolina. Collectively, these resources and the insights shared by our guests this evening should make your probate journey go a bit more smoothly. But I gotta say, I would be remiss if I did not emphasize the importance of consulting with a local South Carolina attorney before starting your probate. The guidance of an experienced professional will help you avoid unnecessary work and pitfalls while shortening the time you ride the probate train. This concludes our show this evening, and we hope you found it informative. Just a reminder that replays of this show can be viewed on the Probate Nation website, and if you want to receive monthly tips on guardianships, conservatorships, and probate, please sign up for the free Probate Nation newsletter. Until next time, I am Richard Ruddy, and this is the Probate Nation.